I'm Brett.
And I'm Alice.
And we are the Prosecutors. Today on The Prosecutors, a special treat, our interview with Maggie Freleng of the Unjust and Unsolved podcast. Hello, everybody, and welcome to this special episode of The Prosecutors. I'm Brett, and I'm joined, as always, with my entzückend co-host, Alice.
What language is that?
That was German.
I
that was
thought
German.
so.
Thank you, Anna.
You did so
That means
well.
Delightful. Oh, thank you. We'll see what Anna says, but...
Thank
I
you,
appreciate
Anna,
that.
for that suggestion. And you know what? Brett has been practicing all day. It's really he really cares a lot.
I could barely work today, just going through that. I'm not going to pronounce it again because, you do something perfect, you just want to leave it there. So I'm going to do that. Well, Alice, it's good to be back with you. I know it's been one of those long days at work, so I'm glad you were able to record tonight. We actually have a special treat for you guys. We did an interview with Maggie Freleng of the Unjust and Unsolved podcast a couple months ago, I guess. Those of you who listen to that podcast, and you should listen to it, this is going to be sort of a repeat of what you've already heard. But if you don't listen to Maggie's show, she invited us on the show to sort of give the perspective of prosecutors. Her show is about people who've been wrongfully convicted of crime, and so we had the opportunity to go on there and talk about one of her cases and talk about sort of in general what prosecutors do.
Yeah, we're huge fans of Maggie's work, not just on this podcast, but all that she's done before. So it was such an honor to get to spend time talking with her and to see, we both listen to her podcast, and you all should too. The amount of research and work she puts into these cases is incredibly impressive. And especially kudos to her, because obviously she's coming from the side where her stories are focusing on how these people have been wrongfully accused and wrongfully convicted. And many times the prosecutors are the villains in these stories. And instead of just typecasting that side, she reached out to us, and we had such a good conversation with her.
Yeah, it was a real pleasure to talk to her. The work she does is so valuable. And there's a couple things we wanted to talk about before we do the episode. There's been some feedback on Maggie's Facebook page, and we were happy to talk to some of the folks on there and really enjoyed that. But a couple things that come up. I think one thing that it's easy when you listen to these really terrible cases where people who are innocent of crime end up spending years in jail or in prison for things that they did not do. And it's as Maggie points out, and as the title of her show suggests, number one, you've got this person who's unjustly incarcerated, and then you also have a crime that's unsolved. You have victims who are not getting justice. And I think when you look at that, it's easy to forget the good that the system does. And there were several people who they talked about they want to reform the system and we need to fix the system and things like that. And I don't think anyone is opposed to reform, but I think people need to remember a couple things. Number one, we have a good system. It's not a bad system. It's not an inherently corrupt system. It has flaws. Most of those flaws are tied to the fact that the system is created by and staffed by human beings who are flawed. And you see that whether it's in racial injustice or people who are innocent and are accused and are judged based not on the evidence but on other things. You see that. But we also have a system that's designed to ensure that justice is served and that is flexible enough to change when it's necessary. our system's been developing over hundreds of years and will continue to do so. And I think it's important to remember that when you start thinking, well, we need to tear the whole thing down and start from scratch. That's a tough thing to do, and coming up with specific proposals is also very difficult.
Right. I think it's easy to lodge kind of attacks at the system and just saying it needs to be reformed. But the real question is, what will it be replaced with? What will the reforms be? I'm always for reforms if, if it can lead to the better. But remember, there are always consequences to every action that you take. Consequences like if you make it harder for certain witnesses to testify, that could lead to more misery and drawn out sort of suffering for a lot of victims. So there are always consequences to each reform you think of, and you have to think about all sides so that you're not caught unawares at the end of the day of what your reforms result into.
Yeah, and I think one thing we heard a lot from people is that there's something in the law called the doctrine of finality. And the idea is that at some point, this has to end. Appeals have to end. Justice has to be done. The case is over. And because of that doctrine, appeals are often difficult. And the standard you have to meet is pretty high. If you're convicted by a jury of your peers, the chances that you're going to win on appeal are pretty slim. An appeal is not a retrial. It's not, we're going to do this again just to make sure we got the right verdict the first time. There are many different things called standards of review about decisions that were made in trials, about mistakes that were made. And some people said, look, I think if a mistake was made in trial, you should get a new trial. And it is difficult to really express the magnitude of the damage that would be done if you had a rule like that. And the reason's pretty simple. There are mistakes made in every trial. There's never been a perfect trial. Something wrong always happens, or at least is arguably so. Judges are making decisions on the fly. Prosecutors and defense attorneys are making objections on the fly. This is not a thing where every time a question comes up, somebody writes a 20-page brief, and then there's a reply, and then the judge has time to consider it, and then he rules on it. If you did that, then a traffic ticket case would take months. Every case would be like the Scott Peterson case, and that's just not the way it is. And because of that, you always do have these errors in cases. And just think about it this way. Imagine someone like Harvey Weinstein and the trial that he went through and his conviction. There are undoubtedly mistakes that happened in that trial, and I am sure those mistakes will be highlighted in the appeal. But one thing you have to show is not just a mistake. You have to show that the mistake affected you in a substantial way, that it did some real harm to you, that it undermined some constitutional right, or your ability to defend yourself. And if you can't show that, then just because you show a mistake, you don't get a new trial. Imagine if that weren't the way it was. Imagine that all you had to do was show a mistake. Think about it this way. How many times should Harvey Weinstein's victims have to sit through trial? How many times should they have to take the stand and recount the things that were done to them? And I think that's true of basically any crime. How many times should the victims of a murder have to wonder whether or not the killer of their child or their son or their daughter or their sister or their brother is going to be punished for what they did? How many second chances and new trials are people going to get? And how clogged up do you want the system to be? If you did that, courts would be incredibly overworked. They would never be able to do anything. Justice would fall apart. So would the rule of law, and our country would be much less safe than it is today.
Right. And those are just some of the balances that we have to keep in mind. And note what Brett is saying. The standard of review does try to weed out and make sure there is a path for a new trial if your constitutional rights have been affected. But what we're not trying to affect is some sort of technicality loophole that anyone is able to meet a very low standard. What you really would result in is kind of setting traps so that there are these minor mistakes that don't actually affect the outcome, but then can be your safety valve if you don't get the jury verdict that you want.
And I don't think anybody's saying the system's perfect, but I do think wrongful convictions are relatively rare. There are tens of thousands of criminal cases litigated across this country every year. Most of them do not result, the vast, vast majority of them do not result in a wrongful conviction. Most prosecutors will go their entire careers without having a legitimate wrongful conviction in their office. Doesn't mean it doesn't happen, and it's the reason that things like what Maggie's doing in the Innocence Project and conviction integrity units are so important. And it's also a reason, and I think something people need to focus on even more. Clemency is a thing. It's not just down to the prosecutors or the judges. If someone is actually innocent, and there's proof of that, and you have a stubborn prosecutor who's refusing to do the right thing, governors, presidents, depending on whether it's a federal crime or not, can give clemency to someone. They can give them a pardon. They can wipe the slate clean. And I know one of Maggie's cases that recently happened. So there are a lot of different ways to attack this, but I think we should be careful when we start down the road of throw the whole thing out and let's start over. I think if you do that, you're going to have a lot more problems than solutions. So just wanted to throw that out there because we heard that a lot after this episode, and we enjoy these discussions a lot, and we enjoy talking to you guys about them. If you have thoughts or questions or comments or criticisms, or if you want to know how certain things work, shoot us an email, prosecutorspod@gmail.com. Hit us up at prosecutorspodcast.com. Follow us on Twitter, prosecutorspod, Instagram, Facebook, all that jazz. But otherwise, I hope you guys enjoy this episode, and we'll be back after the interview. Enjoy.
Hey everyone, welcome back. We are still on a bit of a holiday break because New Year's is coming up. So this week I'm doing just a straight interview, but you will absolutely want to hear this. It is with Brett and Alice from the Prosecutors podcast. Both are real life prosecutors, coworkers, friends, and co-hosts. We do not discuss where they live or work because of their jobs. They want to remain anonymous, but I guarantee you they are both real prosecutors. I know who they are.
I'm so excited. We've been talking about doing this forever. And Alice, I talk to Brett all the time, but I never get to talk to you. So this is...
I know, I'm so jealous. I hope you know that. I'm super jealous of him, but whatever. No, I'm just kidding.
The Prosecutors podcast is one of my favorite. In their podcast, they dive into some of the most notorious true crime cases and use their unique perspective to talk about them. So in this episode, we talk about the other side of the fence because we often talk from the defense side in this podcast. So we get to hear from two real-life prosecutors, and I present them with Darrell Ewing's case, who you know from episode 8. I thought this was a really good case to talk about with them because it covers so many different issues, and they brought to light some really interesting perspectives I just had not thought about. We dive into the case, the evidence, the appeals, and I ask them, would they have prosecuted this case, and why is Kim Worthy still appealing despite the evidence? I also know that this conversation is probably going to bring up a lot of questions, a lot of thoughts, a lot of opinions. So if you have those, come join the discussion on the Unjust and Unsolved podcast Facebook group.
So I want to start with you guys, though, to introduce yourselves, tell the listeners who you are, tell them about your podcast. It is honestly my favorite podcast. It is. I messaged Brett. I'm like, what? It's not out yet? Like, I have errands to do. I need to listen. Like, I love it. Everything you guys do is amazing. So yeah, tell listeners about yourselves.
Well, hey, Maggie, it's great to be here with you. So awesome to join you. My name's Brett. I'm the co-host with Alice of the Prosecutors podcast. And, long story short, Alice and I are both active prosecutors that we do this for our day job. And then at night, we record a podcast about cold cases and really kind of try and dive into that and show, using some of the things we've learned and the techniques we use every day, maybe what we can learn from the evidence that's out there and try and help people understand the cases and what's going on in them.
Right. Maggie, thank you for having us. I'm Alice. And like Brett said, we are real live prosecutors. So we work all day. And we decided to do what we do at work all the time, which is dive deep into cases because we find it deeply interesting. And we found a lot of true crime media out there lacking in the sense that people always wanted to know about the law side. And there didn't seem to be anyone bringing that perspective. And we thought, well, that's our expertise. Maybe we can add something. And that's why we started in quarantine to record this podcast, and me literally in my closet.
You have families, you were full-time prosecutors. Like, how you even have time to do it is just amazing to me.
Well, thank you for what you do too. Brett and I both religiously listen to your podcast, and the type of work you do, we as prosecutors find very, very rewarding, because we say it on our podcast, and we think the majority of prosecutors are there to look for justice. And there are obviously cases where something goes awry. And sometimes there's even prosecutorial misconduct, and that needs to be weeded out because it gives a bad name to the justice system. And when the system breaks down, society breaks down.
The system only works if people trust it, if they trust the police, if they talk to the police, if they think prosecutors are going to do the right things, if they think people aren't being railroaded. And the system needs to work, because you talk on your show about victims of the justice system, people who've been improperly incarcerated. We work every day with victims, people who suffer from crime, and those people deserve justice. And if the wrong person, your podcast is perfectly named Unjust and Unsolved, because these people, it's not just about the person who's wrongfully convicted. It's about the victim who never got justice and their case was never solved. And like I've said with you before, we're on the same team. We really are.
That's what I think. I think it should be the same team. And, you guys are young and you're working in the system now. But so many of these cases, are back in Ronnie's from the 70s. A couple of them that I do are from the 80s. It's this old, the old system that just was so bad. And I know it's naive to, be like, I hope it's better now. We're not doing wrongful convictions, but I really do like seeing you guys as encouraging. And I really hope that we are really weeding out those bad guys and getting to more of, the justice aspect and really getting justice for victims on both sides, conviction integrity units, conviction review units. I mean, maybe I'm naive. I don't know. I have hope. I really
do. Naive, you're not the only one. We're with you.
In your work, have you come across anything, a couple of these cases I've covered, it's been cops mostly. I haven't talked to any prosecutors yet, but cops have quit the force. They've been, they've tried to tell their department, hey, this isn't right. I see something going on here. This isn't right. Jermaine Smothers, my first case. It's a cop that was on the Oceanside, California Police Department. And she made enemies and she quit the force because she was like, this is a bad conviction. This is not right. We need to do something. She basically got pushed out. I mean, have you guys seen anything like that before?
Speaking from personal experience, I feel lucky that I have not seen something like that before. And maybe like you were saying, maybe the new guard is different. Some protections in place. I'll show you just how serious it is for the law enforcement officers we work with. Before we put anyone on the stand to testify under oath, law enforcement, we have to ask them what we call Brady and Giglio questions. Those are Supreme Court cases that tell them that where they have to reveal to us if they have ever been accused or adjudicated as being untruthful, not just in their professional roles as law enforcement, but even if it's a divorce proceeding or if there's a news article written about them. I mean, it is a very wide-ranging set of questions. And here's the thing. If you are law enforcement and you have been accused and basically adjudicated as being untruthful in any area of your life, you are almost dead to us. We basically decide we can't use you. And if we can't use you as the law enforcement officer and if you are integral to the case, we may not be able to prosecute that case. That's how I view my cases. And there are cases where we make the decision, not just based on the evidence, but based on who can testify. If the jury isn't going to believe that person, or there's reason to believe there should be doubt about someone who's testifying who's in law enforcement, that could jeopardize the entire case. I just give that example to show how prosecutors are supposed to follow that high bar for our law enforcement officers. Not to mention for prosecutors, we could be disbarred, meaning we lose our entire profession for something called prosecutorial misconduct. And
I think, I think it would be naive to think that there are no false convictions happening right now. There absolutely are. It's a human system, and it's their mistakes are going to be made. And I don't care what the system is, that's going to happen. And that's another reason we need people like you to shine a light on those cases. But I do think, and I hope that there is a culture today in law enforcement and on the prosecution side, at least in my experience, where it is really sort of hammered into our heads that this is about justice, and we're not going to bring cases where where the evidence isn't there, where we don't feel beyond a reasonable doubt that this person is guilty. And I know I have turned down cases, and I know Alice has turned down cases when the evidence just wasn't there. And Alice is right. I mean, we ask those questions of those officers, and what we're supposed to do is then if we get bad information and we're going to call that officer on the stand, we have to give that to the defense, and they get to use that. And they get to say in front of a jury, isn't it true, officer so-and-so, that you've been found to be dishonest before, or that you were accused of planting evidence, or whatever the case may be. And that is an officer who is not very useful to prosecutors. And that means he's not very useful to his law enforcement agency. And you hope that those people will be weeded out. So that's what we try and do. It's not a perfect system and never be a perfect system, but I think that culture is probably the most important thing.
Yeah. Yeah. And Alice, you mentioned, getting disbarred. I want to talk a little bit about qualified immunity, and I am by no means versed in it at all. I just know that so many times in each of these cases, I look at and go, why can't we hold this officer or this prosecutor accountable? And it's always qualified immunity. I mean, how much do people look to that and say, well, it's all right if I do this because I'm kind of immune?
Yeah, it's a double-edged sword, right? The reason qualified immunity exists is that if an officer or if a person who's working within their capacity think that they are following the law, we want to protect those people, right? We want to protect the good faith people who are within the course of conduct. They think the law allows me to make this seizure of drugs. We want that officer to feel like he can, or let's make it guns actually, because guns affect the safety of the officer. If that officer has reasonable belief as he's on duty in his uniform and his sirens are on and he sees a gun and he thinks the law allows me to take the gun, later, if it's challenged that was somehow a violation of constitutional rights for the defendant, we want qualified immunity to exist to protect that officer who in good faith thought he was operating under the color of law. Because otherwise you have a lot of officers who are second guessing themselves and maybe not grabbing that gun and officers are shot, or innocent bystanders are shot, right? And so that's the reason it exists. But you are right. It can also be a shield. And I'll let Brett take that.
Yeah, I mean, it's been abused a lot. And I think, honestly, qualified immunity does not need to be abolished for all the reasons Alice said, but it definitely needs to be reformed, and courts need to actually apply it as it's supposed to be applied. When you look at a lot of the cases that are the most egregious ones, the court basically says, well, yeah, he shot the kid when he was trying to shoot the dog because the dog was barking at him, but we're going to find that that's never really been adjudicated before. So maybe he didn't know that was an unreasonable action to take. And it's like, of course that was an unreasonable action to take. You're taking qualified immunity instead of applying it in good faith. You're just using it as an automatic get out of jail free card for law enforcement. And you don't need to do that. So I think a nice, healthy balance is good. I'm glad people are looking at it. I'm glad there's pressure to reform it. I think there's a lot of momentum in that direction, both in the courts and in the legislature. So I think you're going to see movement on that in the next few years. Have you got,
what got you into wanting to be a prosecutor? Have you been on the other side? I mean, what was your thought process in going into that?
Well, I spent a year at a big law firm in Washington, and I hated it. I hated going into work every day and working for multi-billion-dollar corporations on cases they didn't even really care about, in cases I certainly didn't care about, that didn't really matter to anybody. And after that, I went and clerked for a district court judge. And the clerkship's just where you work for a judge for a little while. And I worked for a district court judge for a couple of years. And that was really the first time I ever saw the justice system in action. And it was a real eye-opener for me on how the system works and the good it can do and the bad it can do. And I saw good lawyers and I saw bad lawyers. And coming out of that, being a prosecutor was something that from that point forward I wanted to do. And it took me a little while to get there. I did a lot of other sort of legal jobs on the way, but it was something I always came back to. And so when this opportunity came to do the job I'm doing now, it was something I jumped on. But other than that 1 year at a law firm, I've always been in public service. I like public service. I like helping people. I want to make the world a better place. I want to make our community safer. That's something that inspires me much more than getting up and billing 2,000 hours for Google every year.
My story is something similar like that. I didn't think I'd ever be a lawyer, first of all. My parents are immigrants. They did not go to law school. They don't really understand law school in the United States. But I came from, family members who were sent to labor camps, who really had no due process in the countries that they lived in. And really by chance, I was born in the United States. And this was not something I appreciated truly even throughout college. And it wasn't until I started working as a lawyer. And again, I didn't think I'd be a lawyer even after going to law school. I did civil law. That's how I know a lot about FOIA. I did FOIA litigation, and I defended policies and constitutional defense, nothing like criminal law. And I really began to see how due process and rule of law gave me the way of life that I get to enjoy, that a lot of my family members who don't live in the United States have the privilege of having. And so to have, I still get a rush when I get to stand up and represent, the people, which isn't something that I take lightly. I recognize that power is only bestowed upon me, and I shouldn't abuse it. So I feel a lot of privilege and pride in getting to do this type of work.
And I guess, it just got me thinking, is there a lot of pressure for you to prosecute cases? Is there ever, you talk about wanting to get justice for the families. Is that where some of this, gray territory of getting into a wrongful conviction comes from? Do you guys feel pressure to, get justice and prosecute cases?
So there's metrics, just like in every other job, right? Like if I sat and was like, I'm really thinking about how much justice I'm going to bring, but I don't prosecute a single case for a couple years, someone's probably going to be like, that's a lot of taxpayer dollars going to just you thinking about it. So of course there's metrics, but in terms of pressure, I am lucky that in my entire legal career, I've never felt pressured to come to an outcome. And I have had situations where it was a high profile situation locally. There's a lot of news media. People wanted something done and we had to do something. And I had a situation where I did not think there was a legal case to be made. And I made a very, very strong argument that even if the media or the victims wanted this done, there was not a legal path forward, and we should not do something like that. And my superiors accepted that. And it was not easy. It was a lot more work. Actually, it would have been easier to prosecute the case. And I only give that example to say that it's sometimes more work to maybe take the route that seems like there's no outcome, in the end, because there's more work on the behind the scenes. So I am very lucky that I don't think I've ever been told to have an outcome at the end of the day. I'm told to bring cases that I think I can win because the evidence is there. Brett might, I don't know. Brett, maybe your morals are low. I'm kidding.
I think number one, Maggie, I think you make a really good point and you really put your finger on something. It is certainly true that there are just corrupt people out there, and there are corrupt people in prosecutors' offices, and there are corrupt people who are trying to bring cases just to get their names out there or whatever. But I think the bigger problem and the thing you really have to push against, and the thing that can affect even good prosecutors, is the sort of subtle pressure, either because of the facts of the case, maybe the media coverage of the case, or maybe even just to meet some sort of metric. I'll say this: there's plenty of crime out there. It's not hard to meet whatever sort of number you need to meet. What's more difficult is when you have a case that either has a lot of attention, or there's a lot of pressure, or somebody's saying like, hey, we need to do something about this guy. We need to get this person off the street, or, hey, this really terrible thing happened and we can't let this victim go. They need justice. You need to arrest this person. And you see that. And sometimes that pressure is good pressure. We've all seen instances where it is good to have pressure on the authorities to act in cases where they might not act otherwise. But it also can be very pernicious because it can lead people to put aside that nagging doubt in the back of their head that says, I don't know whether or not this person did that, and say, well, we'll roll the dice, whatever, it's up to the jury. And that's really not something that you should do. Yes, it is up to the jury, and we believe in the jury system. But the first step is the prosecutor, who needs to look at the evidence and look at the case and decide for themselves whether or not this is a case that should be brought.
So let's get to Darrell. I sent y'all the case files, and I'm going to give a quick recap to listeners. If you guys post this, just so your listeners know, we are talking about 2009. This is a shooting. 2 cars pulled up to an intersection in Detroit, and a shootout occurred, and one man ended up dead. This was described as gang-related, and Darrell Ewing and Dorico Searcy were convicted of the murder. what we find out is that Darrell had a pretty solid alibi. His family vouched for him being at a funeral. We can, discuss how you would approach that kind of alibi. Family members or a loved one, vouching for someone. But the big thing in this is that someone has repeatedly come forward confessing to this murder before the trial even started. So Darrell has been in prison since 2009. That's over a decade. And I want to dive into this with you guys. So when you started looking at this, where do you start? How do you start looking at a case like this?
You mean in reviewing this case, or if this were our case?
Yeah, your friend Maggie sends you a case and goes, look at this. What did you do? Where did you start?
We listened to Maggie's podcast first. We really do that. And then the next thing is you look for the underlying documents. If there's a trial transcript and any opinions by the district court, by the appeals courts, because there's a lot of legal action in this case. And that's important. A lot of people don't know that those are publicly available documents, and you should go read them, because here's the thing. Not all judges do this, but court opinions are supposed to be written so the lay person can understand them. They should not be full of legal jargon. And if you are reading a piece of legal work that you don't understand because of legal jargon, it's poorly written. Because it's supposed to be accessible to everyone. That is the purpose of law. It is not supposed to be something that is only for some elite bar. Well, in fact, you don't have to be a lawyer or a JD to be on the U.S. Supreme Court. And historically, the very first U.S. Supreme Court justices in our country were not lawyers at all, because the purpose was you have a jury of your peers. You have people who have everyday experiences, who live life alongside you, who understand how life works. And there's no special training that needs to come with that. And that is why we have a jury system of your peers who are not lawyers.
Yeah, and obviously the jury became important in this case, which I'm sure we'll talk about. This is an interesting case.
I find this case interesting because Tyree Washington, the man who from the beginning, from before we even went to trial, has said, I did this, you have the wrong guy. He wrote to the prosecutors. There was this CI that is a very reputable CI, an FBI agent vouched for him, saying, look, this guy says he did this. And the prosecutor dismissed it and said, we already have the guy we're looking for. So I want to talk to you guys about that. I mean, if you were in this situation and you're about to prosecute somebody, which in my opinion, it was a weak case anyway. We don't have ballistics. We have some kind of shaky witness ID. I mean, this man was looking down in his car when he said he identified Darrell. In my very unexpertise opinion, it was not a strong case. We don't have a murder weapon with the ballistics or whatever. And then you have a guy coming forward and confessing. I mean, how would you handle this? How would you handle this confession? How would you handle somebody, an FBI agent coming to you and saying, I think you're getting this wrong? I mean, talk me through this.
So first of all, what people may not know is that this is a strange phenomenon. Sometimes people do confess to crimes that they did not do, especially if they're already sitting in prison or jail somewhere. I don't understand the psychology behind it, but I only say that, and I'm not saying it happened in this case. I only say that to say that just because someone writes to you as the prosecutor or an agent on the case that they did the crime that you're now prosecuting someone else for, that does not automatically mean you stop investigating the case against your target or prosecuting the case against your target. You're supposed to do your due diligence. If you get something like that, because that is serious, right? We don't get those types of confessions all the time. They're rare, but people still do them. You're supposed to run down that guy's story. You're supposed to talk to lots of people. That FBI agent who vouched for, it's not an FBI agent. I think it's an informant who worked for the government, vouched for him. That's helpful, but it's not definitive because that informant may not have worked on this case. The informant is probably still an informant, meaning they probably haven't been burned yet. Being burned just means that you reveal that they work for the government and therefore can no longer continue their previous life of probably living normally on the streets to be an informant, right? So if this informant is still living that life, we also have to weed out, truthfulness. And I only say that because there's a lot of due diligence that needs to happen. Now, are there maybe some agents or prosecutors who don't want to do that extra work? absolutely possible. But I only say that first to say, when you get something like that, you don't automatically stop what you're doing. Now, we don't know all the reasons that prosecutors said, no, we have the guy. Hopefully that's not out of laziness. Hopefully you're not just saying, oh, I'm like 90% there on this trial, I'm not starting over. Hopefully what happened was the person investigated, the story said it's not credible, there's no way that could have happened, so we have to discount this confession. That's one way to think about it. Now, that's not specific to this case.
Yeah, and I'll just say, in this case, I have a lot of thoughts on this case. We could talk about this for a while, but let me say this. I think this is a case. You've got some cases that you have covered where the prosecutors seem like they are bad people who did bad things. This case, I think, is actually just a really difficult case. I don't see in this case the kind of prosecutorial misconduct maybe you've seen in some of your other cases. I think what you have here is you have one person who's dead and one person who's injured, who's been shot. There's probably a lot of pressure on these prosecutors to deal with this. I do think, and you talked about this a little bit, I do think there probably was this guy is a high-ranking member in a gang. Sure would be great if we could get him off the street thing that was going on here. To be honest with you, when I look at the filings, I kind of don't think either one of them did this. I actually think that the guy who confessed is probably lying. And it seems to me, based on the evidence, that Mr. Ewing probably wasn't there. And the reason I say that the guy who did it is probably lying, and I haven't read the trial transcript, I don't know, but just based on the filings, it seems as though one of the critical reasons the prosecution has said that they don't believe him is the person who was driving the van that was shot, who survived, who drove to the hospital, and unfortunately the passenger was killed, says that the shooter got out of their car and started shooting at the van from behind the van. And Mr. Washington, in his confession, says, at least according to what the prosecution filed, so I'm assuming this is true, that he walked up to the passenger side window, knocked on the window to get their attention, and then shot the people. That's a pretty big inconsistency. If it's true that the shooting actually occurred from behind the van, then I can understand why the prosecution's like, look, we just don't believe this guy. We think he's lying. And if he is lying, it may be one of those weird circumstances where that actually hurt Mr. Ewing, because maybe he wasn't there, wasn't doing anything, but then somebody comes in and tells a story that's not believable, and it actually hurts his case, and it makes some members of the jury think, see, he got that guy to lie for him. Now, I don't know that for sure, and I haven't looked into this case as much as I would want to if I, for instance, was writing this appeal. But that's one of the reasons I think this is a really interesting case. Another reason, like Brett said, I'm not convinced that there is the type of prosecutorial misconduct that you've covered in your other episodes in this case. And that's because Tyree Washington's confession was put before the jury. This wasn't hidden. The prosecution didn't keep it under wraps. This was actually presented to the jury. And this is actually, I think, a result of the jury deliberating and imperfect outcome, right? This is an imperfect system with an imperfect outcome. Now, if the prosecution kept secret Tyree's confession, absolutely prosecutorial misconduct, but we don't have that here. And that is a very big difference.
You mean in terms of like a Brady? So they did not allow Tyree to testify. Only the CI was able to testify what Tyree had said. So that was something that did happen. They did not allow him to testify, just the CI could. So I think it could have...
Was he not allowed to testify because he was... Do you know the reason? I only say that because the defense can also call witnesses, and I'm just trying to understand why he wasn't allowed.
That I don't know. I'm not clear why he didn't testify, but I know the prosecution definitely successfully got that suppressed, and only the CI could testify as to what Tyree said. So I do think that could have gone a little differently if Tyree was able to take the stand. So we talked about Tyree. Now I do want to talk about the alibi. So multiple people from his family testified that he was at this celebration of life, something similar to a funeral, wake, whatever it was, something for a deceased relative. I mean, as a prosecutor, if you are looking into somebody and you find out they have this kind of alibi, family member saying they're here. I looked into to try and find if there was photographic evidence. I could not find any. It was just multiple family members saying, yes, he was here. We had a celebration of life ceremony. Of course he was here. How would you approach that? As a prosecutor, I mean, obviously, if you hear that, you have a lot of, you're thinking,
okay, there's a couple things that may or may not be going on in this case that I wonder about, and I just don't know. One of them is how much evidence the prosecution may have that's not admissible. And that's a sort of background thing that we can just never know. We don't know what the police and what the investigative officers are telling the prosecution about this case that maybe could never come into a court for all sorts of reasons that is really leading them to believe this guy did it. And if there is a lot of that background evidence that isn't really admissible and they can't really use, maybe it leads them to think, well, maybe mom or sister or grandma is just saying this. Look, I think when you get this kind of exculpatory evidence coming in, whether it's an alibi, whether it's bad forensics, whether or not it's somebody else who's claiming to do it, the prosecutors needed, and I hope they did, to take a moment to really sit down and think about, are we right here? Do we have this right? And Alice and I, we work on a lot of cases together, and we spend a lot of times talking about this, even when we think it's rock solid. We have sat in a room recently and said, is there any way that we're wrong about this? Is there any other way to explain this? Is there anything else that we're missing? And I assume they did that. I hope they did that here. And it's important. And one of the reasons it's important is because prosecutors really are the first step in preventing wrongful convictions. They need to be making the hard decisions about what to charge and what not to charge. It's an important part of the job. And it's a part of the job I think people forget about.
Yeah, that's really great to hear. And I just want to say, in my opinion, I don't think that they did that. I truly don't. And I talk about it a little in this. In my opinion, and me and Darrell's mother talked about this, I do think that there was this kind of, they're trying to clean up Detroit. We're in that era. We're cleaning up Detroit. We're just scooping up particularly young Black kids off the street, getting them for a crime. And in my opinion, that's kind of what I think this was. He was in a gang, and Darrell talks about how this wasn't a gang. He was a club promoter. Everyone testified that Darrell, even if there was beefs, he was not involved in these beefs. He didn't even really know Searcy. He knew him from the street, but the connection was very circumstantial. It was a phone call on his sister's phone to Searcy. It was all very, to me, again, I feel like it was circumstantial. And I guess, can you talk to me a little bit about building a case on circumstantial evidence? And you can tell me I'm wrong if you want to.
No, Maggie, the reason both of us kind of chuckled when you asked that question is you just posed a perfect law school question, which is weightier or which is more appropriate to use, direct or circumstantial evidence. And a lot of people may wrongly answer direct evidence, of course. And the answer is, in the court of law, they are equal. and a lot of people may not know that.
And what Alice says in Ronnie Long's case, Ronnie Long just got his pardon. Congratulations to Ronnie. In Ronnie Long's case, there was a witness, right? He was identified by the victim. Now, you do a really good job of showing why that direct evidence is faulty. And I think we are seeing more and more the problem with direct evidence. And the only difference is direct evidence is just somebody standing up and saying, yeah, I saw him do it. I saw him shoot the person, right? So I think what you're pointing out is weak circumstantial evidence. DNA is circumstantial evidence. Fingerprints is circumstantial evidence. Circumstantial evidence is just anything that's not he did it. It's anything where you have to draw an inference. Well, his fingerprints are on the gun. That probably means he held the gun. That probably means he shot the guy, right? In this case, the problem that I have with this case is it really seems like we can quibble about whether or not it was a gang. I think he was involved in a criminal enterprise. I think he was a club promoter that sold drugs. I think his group probably did have problems with this other group. It's probably the case that somebody that he knows or associated with did this. He probably doesn't even know about it. Probably doesn't even know who did it. I think he got drug into it because of that. And I think there was a lot of weak circumstantial evidence, weak identifications. One of the biggest problems in this case isn't circumstantial evidence. It's the fact that the person saw him through a rear view mirror, right? It's like the worst possible way to identify somebody through while you're trying to avoid being shot. So I think that's the biggest problem in this case is there's just not a lot of good evidence that he was even anywhere near the scene of the crime. And if I had, I continue to predict things, I think he's going to get a new trial. And I think I think a new trial will be ordered. I do not think a trial will ever happen in this case. I think he is probably, If I were the prosecutor in this case, I would be seriously considering at least offering him an Alfred plea and just being done with this.
So I was going to ask you, but Brett, I think you might have answered it. I mean, would either of you have prosecuted this case?
I mean, that's a tough one. I hate to step into this prosecutor's shoes. I mean, like I said, I know that you probably don't agree with us on this. I just don't think this is a malicious prosecution.
I don't think it was either, but I do think. Go ahead.
So here's the problem. If you have a gun case, right, like a felon somebody's been convicted of a felony, you can't own a firearm if you've been convicted of a felony. And if you're found with a firearm, you can be charged with that in both state and federal court, usually. If you had this kind of evidence in a felon and a firearm case, you'd probably just let it go, right? You'd probably say, you know what? We're just going to let this one go. Not a lot of good evidence, really close case. Give the guy the benefit of the doubt. We'll see him next time, if there is a next time. The problem in this case is you have a dead body. You have someone who's been murdered. You have someone else who was injured. And I think this goes back to a question you asked much earlier about pressure. It's not pressure from the boss necessarily, or pressure even from the public. It's just the pressure of the police are coming to you and they're saying, look, we think this guy did it. Here's the evidence he did it. This guy is dead. You need to do this. Turning down that kind of prosecution, that is hard. I mean, that is a hard one to do because of what you're essentially saying, because once again, it's kind of like the West Memphis 3. Nobody in West Memphis is investigating those crimes. There's no police officer out trying to figure out who actually killed those kids. They got the Alfred plea. They're guilty. They're done, right? And in this case, if the prosecution had said, we're not going to prosecute, that's the end of the investigation. That murder is never going to be solved because the police are like, look, we found the guy. You said not to prosecute it. We found the guy. We're done. And I think that is the hardest question you've asked all night is that one.
That's a really good point that, of course, we work with law enforcement, but we cannot investigate cases without law enforcement. If they're done with a case, we can't go out and run the beat on the street, unfortunately. If they're getting the directive from their office, you could be the closest of friends, but they're like, look, we have to professionally disagree here. We have solved the case. We are closing our case. We can't open a case to investigate. We don't investigate cases. We ultimately prosecute. But there's two sides of that, right?
Yeah, the best relationships, they push you and you push them. You know, they're pushing you to do a better job and you're pushing them to do more investigation. And I think usually, and it is weird. I mean, it is kind of, unless you've been in it, you just don't know this, that you're working hand in hand, but you know, you gotta, we're independent of each other. Right. So there are times that there are disagreements and there are arguments and there are falling outs and there are hurt feelings. And there are times when we don't want to prosecute a case and they really want to prosecute a case. I mean, that happened. So it is an interesting relationship.
So let's talk about now. Darrell is in the middle of his appeals process. And something that took me until I started looking into this stuff and doing this podcast a while to understand is that Darrell is not appealing on what's called actual innocence. You know, Darrell does, you know, he says he is actually innocent. But what we're talking about when we're talking about Darrell trying to get out of prison or on some technicalities, the jury, he's not trying to get out right at this moment on I am innocent. Here's the evidence. Let me out. What we're talking about for listeners is the fact that there was a jury member who almost immediately after trial said that I was pressured to give a guilty conviction by other jurors who did their own outside research, which, Brett, as you mentioned, you cannot bring outside research into a jury room. So let's talk about the actual appeals and the logistics of Darrell's appeals.
So I've done a lot of appeals. So this is one thing I do a lot is read these lower court opinions. And there are a lot of them in this case, because what you essentially had is Mr. Ewing Darrell. He was convicted, and the way it works, he's convicted in state court. So the first appeals all go through state court. He makes his appeals in state court. Those appeals were all rejected. At that point, he then goes to federal court, something called habeas corpus, which people may or may not have heard of. It's a Latin term. Doesn't really matter what it means. Basically, it means if you've been convicted in state court after your state appeals are done. You can go to federal court and you can say, hey, I've got this federal constitutional issue and the state court didn't deal with it, so I want you to deal with it here. And the one in this case is whether or not the jury was tainted by outside information. So he loses in state court, then he goes to federal court, and the district court says, yeah, actually, I think there's a problem here. Stuff not from the case came into the jury room. And that is just fundamentally problematic. The whole point of the trial, of the rules of evidence, of having a judge, of having a defense attorney who objects to questions and objects to evidence, is ensuring that the only evidence that the jury sees, the only information the jury has about this case, is evidence that is properly before them, that is not unduly prejudicial, that won't lead them to make emotional decisions or decisions based on things outside the case or the person's race or maybe the groups they're involved in. Keep that out, decide on the facts. And in this case, there was information coming in that would never have came in through the courts.
And Brett,
and in fact, information that the courts had specifically said shouldn't come in.
Yes.
And Brett says something really important in there that I want your listeners to understand. The relief asked for in the habeas proceedings in federal court was not to overturn the conviction. And that is very difficult for a lot of people to understand. Now, the federal court, because they did not sit in the trial, they need to have the evidentiary hearing before the court that has the jurisdiction of the trial, right? So the federal courts could not even say this conviction is bad. They can't throw out the conviction. That was not the relief brought before them. All they can say is open it up and have a hearing.
Right. And there was a hearing. A 3-judge panel ruled again that Darrell should be retried or released.
One thing I think is interesting about this case, and that I think would be interesting for you to focus on, I think your focus has mostly been on prosecutions and prosecutors and the problems that prosecutors can have and where they can go astray. This is a really interesting case because it's about juries, and it's about how juries can go astray. And in this country, and traditionally going back to the British system, we just have huge faith in juries. The whole point of the jury is to protect people from the government, because at the end of the day, it's not some government officer who's going to decide whether or not you're guilty. It's a jury of your peers. And because of that, our system is really stacked against defendants in appeals. Once a jury says you are guilty, unless you can show some fundamental defect in the trial, it is going to be almost impossible to overturn that. And you've seen that in this case. But I think it's worth discussing and it's worth debating in society whether or not we put too much faith in that system.
Also maybe my naivete, but I feel like jurors these days are more aware of these kinds of issues. They might be looking more critically. I mean, certainly we're much more aware of wrongful convictions these days, coerced confessions. I think jurors might be a little more educated today. And I don't know, maybe I'm just wrong.
No, Maggie, I think you're absolutely right. You've hit on something. I'll give an example that's not directly on point here, but before all the crime shows on like the CSIs, the DNA testing, before those shows were really popular, you never needed DNA in trial, right? As those shows became popular over a decade ago, over and over, we've heard from prosecutors who are more senior than us. They were like, once those CSI and SVU, all of the shows came out, everyone wanted DNA, even when it was a case not about DNA. They're like, eyewitness, you saw him shoot the guy. Was there DNA? Nope. Why didn't you send it off for DNA? They're like, because there's cameras and we're all here. And the jury will say, nope, I watch lots of CSI and there's got to be a DNA. And law enforcement actually had to change the way that they investigated cases because jurors wanted DNA. And now you're absolutely right. I think there has been a lot more light shined on improper conduct for law enforcement and for prosecutors. And I do think the average citizen is more aware that these can be issues that they need to look out for. So we've seen it. Even just in the jurors that we see now, they definitely ask more probing questions. They're not willing to just take a law enforcement badge as truth. So I think there is hope with education of the people, right?
Yeah. And I do have one last question, and it's probably the toughest. So Kim Worthy has just put in again her newest appeal. So now they're waiting for the Supreme Court to rule on this. I mean, I guess, I've emailed her multiple times, and, every time she emails me, she goes, we're not talking about actual innocence. We're just talking about, the juror misconduct, which I understand that's what we're talking about. But I do also wonder sometimes, just like, how do you sleep at night? How do you sleep at night when we know there's another confession and you don't have any evidence and there is no gun, and just let it go? Can you just let it go? Like, that's what I'm just like, why are you still appealing? Why are you fighting tooth and nail? And Brett, you talked a little bit about this, but like, I do want to know from you guys, like, why would someone fight tooth and nail? And she came in as this whole like progressive district attorney, and we started a conviction review unit. And then you have this case like Darrell, where it's like every time the court rules, she is appealing. And I think listeners want to know maybe what is that about?
So one duty that people may not know that prosecutors have, that they are accountable to the taxpayers, is that when there is a conviction, it is actually our job, whether we like it or not, to defend it. Right. And that can be very frustrating to people. But when the jury has spoken, we are supposed to defend that conviction. And there's supposed to be there's supposed to be vigorous advocacy on both sides. Right now, because let me flip it on its head and show you why that is the system you should want. Let's say that the jury comes back not guilty, and the prosecutor can say, I think he's guilty, and I get to decide that. That could never happen, obviously, in our legal system right now. But you see why it's flipped, and you don't want to give that power to the prosecutor to be able to do that. Now, the decision not to appeal is a very, very big one, especially when you have a jury conviction. A lot goes into that. There are pressures, elections, like you said, whether that's right or wrong. There's the victims. There's the system, right? There is actually the protection of the jury system that you are going after. Now, that's all talking pie in the sky, not specifically about this case, but it can be very difficult for people to say, why are you trying to defend a conviction? Because that is the job of the prosecutor at the end of the day, because no one else will. That's the thing. The taxpayer can't defend that conviction. The victim can't defend that conviction. The only person who can is the prosecution.
Yeah. And like I said, I've done a lot of appeals, and I mean, a couple things on this. Number one, we do have an adversarial system. So there is this idea that he has someone who's fighting for him, and there's somebody who fights for the jury verdict. Like I said earlier, we put a lot of faith in jury verdicts. We have a jury verdict here. We have 12 people who said he was guilty. But I don't have any problem with them making that argument and allowing the justice system in the end to decide. And if the Supreme Court of Michigan says, which I think they will say, I think probably they just won't even take this appeal. They'll just say, no, lower court got it right. Then it's going to move forward. And I think one of the things about this case, and Alice and I talked about this a little bit, this is not a case where the system has failed. It's a case where the system is working. The thing I think that is bothersome is how long it takes. This has been going on for so long, and the system is working, but the appellate process is it takes years and years and years. And I think one of the frustrations you have is every time she appeals, that adds another year. And if he's innocent, it's another year that he's in jail. And I think that's definitely something to think about. And I think it's something that goes into the calculus about whether or not to appeal. But Alice is right. Just as a matter of course, for every prosecutor's office in the country, the default is you defend the verdict unless it is so obviously wrong that you would be embarrassed to stand up in front of a judge and make the argument you're making.
And the reason that is of course, this case involves a real person's life, but the appeal is more than just that case. This is about all future jury misconduct. Imagine the loophole if all it took was the first prong of jury misconduct to come in. All that has to happen is for the jury to bring in something from outside, and then any jury conviction could be overturned. Imagine if you are that one holdout and you know that it's going to not go your way. You're not going to be able to turn this jury around. Bring in a Facebook page. You know what's going to happen because of that loophole, right? That can be frustrating, but that's why these appeals actually are important for the prosecution to continue, because it's not just about the one case in front of you. It's about the entire justice system. And we hope that the entire system will work on the whole for people. It probably failed in this case. And that's why we hope and we think that he will get a new trial. But what you're also having to think about and preserve is the entire justice system.
Yeah, it's amazing to hear everything you guys have said, and that totally makes sense.
And here's the thing. pressure does work, right? Media attention does work. So you covering this case, it is doing something, if not even just to let the rest of lay people who may not follow this case closely know about this type of work so they can be on the lookout for this type of conduct. So what you're doing is very important. I bet you your emails don't just go into a junk folder. They're read, right? She may not be changing her position because of your emails, but when people write us, when people call us, it doesn't go into a deaf ear. It really doesn't, because we're humans too.
Yeah, I mean, I don't, obviously don't have any inside information, but I have a feeling that they're doing what they think they need to do and what they have to do and what their sort of ethical obligations are as prosecutors. I think once the appellate route is foreclosed, a lot of the stuff that you've been doing and other people have been doing is going to have an effect. And like I said, we can come back and you can laugh in my face if they decide to retry this case. But I kind of wonder if once the appeals are done,
that was going to be my next question. I mean, what are the chances of them retrying it? I mean, at this point, we still have Tyree Washington confessing. We still don't have ballistics. We have a very shaky. I mean, what are the chances of retrying this case?
I mean, if anything, the fact that so much time has passed works against the prosecution. Memories fade over time. Your eyewitnesses, man, you put a decade between them, that is not very convincing to a jury. People die, literally, witnesses die from old age. Evidence gets lost. Those things all happen and they factor into the decision to prosecute. So in addition to the points that you've made, time works against prosecution too. So I wouldn't want to retry it, if anything, for the work.
I'm so happy you guys joined me at this late of an hour on a Friday.
Thank you for having us. So and again, thank you for the work you do. We think it's very important.
Yeah, we love your show. Your show is awesome. I could listen to you talk about this stuff forever.
I love your show. Everyone needs to listen to the Prosecutors podcast. I'm obviously going to post it and link to it. You guys are absolutely amazing.
Thank you, Maggie. Thank you so much.
Thank you, Maggie.
Y'all, Darrell is still in the appeal process, and there is still time to write Prosecutor Kim Worthy and tell her to release Darrell and not delay this process any longer. Please write her. We can make a difference. We have all of this on our website. You can also find ways to listen to the Prosecutors podcast on our website, unjustandunsolved.com. If you want to support the work I'm doing, please rate and review and share this show. It takes 2 seconds and the payoff is huge. The more people who hear and share, the more reviews, the more attention, and the more likely word about these wrongful convictions will reach the right people. Unjust and Unsolved is produced and reported by me, Maggie Freleng, with editorial consulting from Amber Hunt. For more information and resources, go to unjustandunsolved.com. You can find Unjust and Unsolved on Twitter and Instagram at Unjust Unsolved, and join the discussion on Facebook at Unjust and Unsolved Podcast Discussion Group. Unjust and Unsolved is a production of the Obsessed Network. You can find all their shows at obsessednetwork.com.
All right. I hope you guys enjoyed that interview. Thank you again to Maggie for having us on her show and for providing that audio. We really appreciate it. Had a great time. Would love to do it again.
Absolutely. Thank you, Maggie. She's probably been the most unexpected surprise of our podcast friends. We are so thankful for what she's doing and also for including us on this very important episode.
Yeah, we've been very lucky. The podcasting community in general has been really wonderful to us, and we were so thankful to have that opportunity to talk to Maggie, and I look forward to, who knows, maybe we'll have her on our show one day. That's all we have for today. We'll be back next week with yet more Scott Peterson. I promise you, we're almost finished. But until then, I'm Brett.
And I'm Alice.
And we are the Prosecutors.
Did you know, actually, you want to know a crazy fact? I was a Girl Scout in high school. It was like a bunch of my friends and I formed a troop. And I sold the most Girl Scout cookies when I was like a senior in high school.
I thought Girl Scout cookies were just for like kids to sell.
Yeah, I mean, it was not fair. I literally drove my car to school and like popped my trunk like a drug dealer. And high schooler students just bought, boxes of candies because we had amazing metabolism back then. And I would sell dozens of boxes of Girl Scout cookies at lunch every day. Snooki. Oh, it's her name, Snooki.
She wanted
and
her
she couldn't.
to trademark her name, Snooki. How could you not trademark Snooki? I think Snooki is unique enough.
Snooki with a Y is already trademarked. So hers is not because of copyright.
Oh, really? Oh, there's a cartoon cat in children's books. I didn't realize that.
I'm like full of random Snooki knowledge.
Wah wah. Nobody knew who Snooki the cat was until I applied for a trademark. I'm the real Snooki, bitches. There you go.
If you're looking to streamline your audio advertising buys and maximize your revenue, look no further than Triton Digital's programmatic audio advertising exchange, A2X. The private exchange consists of only licensed broadcasters and top-tier internet radio publishers, assuring the quality inventory and brand safety you can trust. Visit www.tritondigital.com to learn more.